Good afternoon, everybody. I hope everybody's having a great day. Today's October 14th, the day that the trial for Sarah Boone has officially started with jury selection, which has not been recorded. So we have been just waiting for the trial to start to be televised, right? So here I am with Whisper. If you haven't met Whisper, this is my guy. Hi, everybody. And we want to do part two today of the 58-page letter that Sarah Boone wrote to this judge in June of 2024 to get a little bit better understanding of who we're dealing with, right? And for me, it's been helpful because usually I tend to be very defense prone and I'm like, oh, I feel sorry, she was drunk, she didn't mean to. So this letter is actually helping me to understand Sarah as a person, right? Who is not drinking, a person who is completely having her wits about herself, and she's writing these types of letters. So, without further ado, yesterday we stopped on page 7. So, I'm just going to read a little bit of, I'm going to make this a better screen. Um, I'm going to read a little bit of where we left off, where she was talking about her defendant, her attorney at the time. Okay, so she was saying she's very frustrating. One, and then she gives us the definitions of frustrating because Sarah's like, Judge, if you don't know what that means, it means one, to balk or defeat in an endeavor. Two, to induce feelings of insecurity, discouragement, or dissatisfaction. Three, to bring to nothing. So so much I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, and appropriate manner. So as usual, here Sarah has to give us three adjectives, right? In a hopeful, progressive, and satisfactory manner, because it doesn't seem to Sarah that we are able to understand what she means unless she gives us three words to describe the thing. Um, I added pretend judge in quotation marks, which in this case is appropriate. But yesterday, when I was reading this, she had a lot of quotation marks for things that didn't make sense, like justice. Okay, that makes sense. But system. So quotation marks, which I kept calling parentheses by mistake, quotation marks could mean an ironic uh, manner of expressing yourself through words. And that's what Sarah is trying to do when she uses quotation marks most of the times. But here she's using it appropriately. I added the pretend judge to our interactions so she could calm down and ease up on her condensation. Condensation, offensive demeanor, and obvious prejudgment. Always three. She seems like everyone else not to remember I am innocent until adjudged otherwise. She treats me as if I am not. Okay, so in this case, I am innocent until adjudged otherwise. She's correct. Okay, but I don't know about all the other things she's talking about her previous attorney. So here's where we're starting today. After my introduction and explanation for with pretend judge in the room or on the phone, I am trying to help her understand how she's making herself extremely unwelcoming. So this is Sarah talking about her previous attorney, right? Because I am so wonderful, I am so smart, I am trying to show this stupid attorney how she's coming off so unwelcoming. So the lack of self-awareness is the theme always with Sarah Boone, right? Because who is unwelcoming? The unwelcoming one is the person who is always aggressive, always calling somebody else names, always telling how other people are not doing enough, not doing their jobs, not, they're not being competent. So you're being unwelcoming, Sarah, but okay, let's keep going. When in front of a real judge and in the courtroom is how she should treat me. her clients at all times. I should not have to invent, pretend judge in order to be, and am not at all wrong for wanting to be respected. No matter the outcome, I am innocent until adjudged otherwise. Sure, correct. My attorney, everyone should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically and effortlessly. Wow, there's a lot to unpack here. Okay, so going back up, I should not have to invent pretend judge in order to be respected. I'm not wrong for wanting to be respected, no matter the outcome. Uh, no matter the outcome, I don't know about that, but sure, you have the right to be respected. You should not apologize for wanting to have to be treated with respect, no matter what the circumstances are. But after the outcome, if you're found guilty and people don't respect you because you murdered someone, you can't just like force people to respect you, right? And the fact that she's saying I'm innocent until otherwise, okay, correct. But now she's saying that my attorney and everyone in the world should be fair. Sure, people should be fair, but are they fair? We can't control what other people do, right? They should be unbiased. That is never happening. People are always biased on something. All of us are biased. Trustworthy. Not everybody's trustworthy, including you, Sarah, because George trusted you that you would open the suitcase for him. And did you? No, you did not. Um, so you expect other people to be trustworthy, but you are not trustworthy, right? Okay. Everybody, everyone should be honest, supportive. Everyone should support you, right? No matter what you did. Informative, protective. Everyone should protect Sarah automatically and effortlessly. Okay, just automatically. That's how the world should be. And if you hear some panting, I don't know if I'm saying it right, it's because Whisper just walked outside. He drank water. Okay, so he's not thirsty, but he does pant. He does pant sometimes. So everyone should be automatically supportive and effortlessly. So that's what she thinks the world should be. But the world is not made of butterflies, and the world is not the way we think it should be, Sarah. The world is reality, and we need to wake up for it, and we have to live life on life's terms. So let's keep going. I should feel, I should feel secure, highly confident, proud in her, that stupid attorney, representing quotations my life. I do not, and have said to her many times regarding her monumental disbelief in me and my case, which I believe contributes greatly to her inimical mimical attitude towards me. I am hoping by this letter she will pick up the sword of injustice and fight alongside, not against me, as so many unmotivated, overwhelmed, weak attorneys who who bowed out ungracefully and crept away from the battlefield unsuccessful. So the attorney that is no longer in her case should pick up the sword of injustice, because this is a very unjust case when Sarah is being and she's being in jail and tried for murder because there's a videotape of her murdering someone. So the attorney should pick up the sword of injustice and fight alongside Sarah. Let me take one quick pause here to put Whisper on the floor in case he wants to go out and get some water. 1 second. Sorry about that. So then she keeps going saying, my case equals bizarre, equals unknown, equals different, equals ignorance, equals misunderstood, equals unfair. So let's go back and fact check Sarah, right? Is her case bizarre? Absolutely. Absolutely. Who plays hide and seek with one person who zips him up in a suitcase and, laughs at it and then leaves him there? Is your case bizarre? Yes. Is your case unknown? No. Everybody knows about your case. There are millions of views on YouTube, on millions of channels watching the suitcase murder trial video. You know, there's so it's not unknown. Is your case different? Sure, your case is different, Sarah. You correct there. uh, my case equals ignorance, misunderstood, unfair. Well, that's her favorite word, is to say that her case is unfair. The detectives are being unfair. Everything is unfair to poor Sarah Boone. Okay, so let's keep going. This does not mean my case can't equal success, and in more than one way. While everyone continues to ring their bells of malevolence, I am ringing mine of hope, honor, plausibility, boldness. Listen, listen to the bell. Can you hear it? Did you hear it? I am not a murderer. The justice system should equals fair, faith, trust, respect. Innocent until and if I adjudged otherwise. 3 point back. Sarah Boo. Heart. Confused cat name. Yes. Thanks. Oh, confused cat meme. Yes. Thank you. Uh, so let's go to the page 11 of 58 here, June 4, 2024. Video visit 12 minutes. In addition to my previous letter, intended for hand delivered on 6/7/24 at my status quotation irony, right? Status hearing. Today, my attorney made a video visit to go over everything I've been asking her for and have also sent to her personally in two letters, 510, 525, all on the public video visitation box, where on both sides of me, less than 5 inches away from my visit, other inmates were having their visits too. Also, I have explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not in any way feel comfortable having in depth private meetings regarding my entire criminal case on the visitation box, where there is no privacy whatsoever and held in an open bay dorm with more than 62 other interest all years inmates. I cannot fully participate, if at all, from the entire dorm, officer included, trying to participate also in my case. Now, if you are the attorney and you have this nightmare of a client, Sarah Boone, what would you do? Because every time you meet with her, she writes letters to the judge to call you incompetent, to say how you are not doing anything, how you treat her as if she's guilty. So, yeah, videotape it, videotape the meeting so that you have proof of how it occurred. But then when you videotape it, Sarah's gonna do what she's doing here: complain. She's going to complain that she cannot participate in this process because everybody can hear it. So cry me a river, okay? As always, my attorney did not listen or care after I repeatedly tried reminding her of my unsecure environment, barking at me. I can listen or not, still going, over speaking and not at all allowing me to respond. Well, I'm glad that the attorney videotaped it, right? Because that will show if this videotape will show other human beings who are normal and who are, they have self-awareness and they can watch something and make a determination of what they think of it, not like Sarah, who's delusional. But he will see if the attorney was actually barking at her, not us, but if there was a judge to look at it, because those are privileged conversations. And we will see if Sarah is trying to speak and the attorney is not allowing her. So, after repeating over, after repeating to her over and over and over 3 times, while she's beginning to speak louder and over me still, to please schedule an in-person meeting where all can be discussed further privately with no success of being heard, I disconnected the visit telephonically. So she hung up on her. She uncooperatively, she is impossible. She previous letter, she previous letter or ask her for a, oh, see previous letter or ask her for a copy. Sure, I'm sure the judge's like, I can't wait to see more letters. Ask her for a copy of the 2 I sent her. I was trying to remedy or lessen before sending this to you, Your Honor, and not having to include. Now it's a race to the pulpit. My question, please, who acts like that and still be able to call themselves professional quotations marks are irony. The visitation box is primarily for family and friends to connect. And if a must from an attorney, reminders, notices, quick questions, not high level confidential case information. First of all, I'm sure the judge, who is a judge who went to law school, he knows the rules and what is allowed and what is not allowed. And I'm sure that after all the attorneys and all your complaints and all your attitudes, you brought this upon yourself, Sarah. So the fact that now you're angry because you have to have the attorney conversations here in this little box and they're being recorded to show that you are delusional, it is what it is. It is what it is. So let's continue here. She, like other former attorneys who always, caps, always blame their dysfunctions on me, said, you don't like the answers I give you. What answers? Screaming in caps. See pages 1, 2, and 3. Okay, so here you go. The attorney from June 2024, like all the other attorneys, okay, always blame their dysfunction. So every single attorney has dysfunctions with a Y on her and say you don't like the answers I give you because imagine the attorney. What would the attorney's answers be? There is video of you. Like you need to like consider a plea deal. You need to plead guilty. It's not looking good. And Sarah's like, you need to have a positive attitude. Just because I was drunk doesn't mean I was drunk. And just because I put him in a suitcase doesn't mean I put him in a suitcase. And just because I was laughing at him when he was saying I can't breathe, it doesn't mean that I killed him. Okay. So you need to have a better attitude about all this, attorney. So here she continues in caps, right? I am not the problem, except that I want to and should be treated fairly, with respect, acting more professional than the paid. I've been doing this for over 40 years, quotation marks, professional. After so long and in all the experience, common courtesy, customer service, and listening skills should have been acquired. Well, what is the world that Sarah lives in? Saying that the attorneys need to have customer service skills? Oh my God, this is not a store. This is not a store business that you're going to go buy products. This is, public defenders trying to help you. All attorneys, do you remember why you even wanted to be one? Remind yourself, judge. No one listens, and it works in everyone's favor but nine. That I am a murderer stuck in jail so they can pin on me they're uninterested, unmotivated, hopeless. They're going to be leave me over her naughty attitude. So the attorneys have a naughty attitude because they want the jury to believe that Sarah is a murderer, right? That's what she's saying. The defense attorneys want the jury to believe that Sarah is a murderer, and they are against her in this little delusional letter here. They're against her. So they're going to believe me over her naughty attitude that I am a murderer. I am not, wait, let me show you guys the letter. I am not wrong for not thinking less of myself because everyone else has and does. This present attorney foremost. Okay, here you go with the quotation, right? The irony. The justice system expects me and other inmates, aka clients, to accept its subpar. Okay, again with the several adjectives for one circumstance: subpar, nonchalant, hypocritical. Next on the list, attorneys. Next on the list, attorneys. They keep aimlessly throwing darts for. And malappointing, praying they don't withdraw. And now there is a huge cap. So this is a huge screen. I have not fired any attorneys appointed in my case. From me expecting the highest equal standards possible for wanting the absolute best outcome in my preposterous, mismanaged case. And representing myself is not an option, as both judges have now threatened me with from being outspoken and intelligent. We cannot forget what Sarah Boone thinks of herself, right? I am an outstanding mother. I I do everything. I do everything. I excel at everything, and I do all the things. And I am a straight A student. I am a wonderful, intelligent person. So now, because I am so intelligent and I am challenging the justice system, you guys are going against me. So the judges have now threatened with being outspoken and intelligent in all my observations of the ongoing abuse I am and have experienced. I have no new experiences from it, always being the same. Blame Boone. I refuse to be moved in wanting respect, no matter who everyone thinks I am. Clarity, inclusion, honesty, and professionalism. And another great reason not to have my case meetings on the public visitation box is my personal confidential inmates information such as my visitation lists from 2020 to 2023 with names, etc. My interactions with inmates and officers. I imagine they're probably not great because you don't seem to be a very cheerful and very welcoming person. I don't know if you got any friendly interactions, but it doesn't look like it. What I eat, when, and my personal jail calls also being thrown online. For what? Well, honey, as you and many other inmates who are in prison should know, is that phone calls are recorded and then they are public. Unless it's a private phone call with you and your attorney, and that is considered privileged. But trust me, everything you say in prison is being recorded somewhere else. So don't act. I mean, you just called yourself super intelligent, right? So, you know, why are you so surprised your personal jail calls are being thrown online? For what? I hate me. Oh, to hate me more or try to get others to because I don't eat breakfast or because I know some Latin, have short hair, my penmanship is nice. No, Sarah, I think people don't love you and they're not like defending you because you showed extreme cruelty when you zipped up your boyfriend in a suitcase and started laughing at him when he was yelling he couldn't breathe. I don't think it has anything to do with your short hair or because you don't eat breakfast. But I could be wrong, because like you called the internet people are just idiots or something. or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset from not having to fabricate, mutate, splice, split. I don't know what that is. Edit. The word apparently knows all. What's next? How many times I go to the bathroom and what function I perform. Here goes with the caps lock again on screaming. No one knows anything, nor seems to want from being comfortable in their corruption and starting to be on top with ratings, web hits, and money. My case details, if anyone forgot, and if you think about it, all that keeps getting plastered and plagiarized, posted, and poked fun at about me, it's all in my favor, proving myself right about all the mindless lemmings, shut ins, the justice system advantageously abusing and profiting from everything in my case before my trial and before I've seen. So here she's complaining about the people who are making videos online about her case. You know, those people making videos online about Sarah Boone's case, she's not a fan of them. She doesn't like it. And she might have a point that it's not great for defendant to have their case, you know, in the public opinion before it goes to trial. But that's not something that she's able to change at this time. Maybe they can change the legislation on that, but the public does have a right to be part of the trial because the public is the one that pays the taxes, right? So they're paying for the attorneys, they're paying for the courtroom, they're paying for the judges. So the public is paying for this whole ordeal just because you decided to kill somebody and then you don't like that the public has access to it. It's not how the world works. So please be sure to read my attachment for FRCP Rule 3.220E, restricting disclosure. Am I the only one who thinks of these things? She's talking to a judge, okay? When can I win in anything? It's coming. I am not the problem. This is like the third time she says, I'm not the problem. When you have to keep saying you're not the problem, maybe you're the problem, okay? And if anyone were to slip on my slides and have to experience, tolerate, deal with any of what I have and am, would bravely be doing the same. Don't knock it until you try it. 3 point back, race to the pulpit. Again, always seraphim. Mic drop, right? So now we go to the page 17. West Florida statutes annotated. Florida Rules of Criminal Procedure 3.220 VI, which is 6, discovery. 8. Notice of discovery. After the filing of the charging documents, a defendant may elect to participate in the discovery. Okay, so here she's explaining to the judge the rules of criminal procedure, which she was complaining about here because people have access to her case online. And she calls these people the mindless lemmings, shut ins, the justice system. Okay, so here are the rules. After the filing of the charging document, a defendant may elect to participate in the discovery process provided by these rules, including the taking at discovery depositions by filing with the court and serving on the prosecuting attorney a notice of discovery, which shall bind both the prosecution and defendant to all discovery procedures contained in these rules. Discovery obligation within 15 days after service of the notice of discovery, the prosecutor shall serve a written discovery exhibit which shall disclose to the defendant and permits the defendant to inspect, copy, text, and photograph the following information and material within the state's possession or control. A list of the names and addresses of all persons known to the prosecutor to have information that may be relevant to any offense charged or any defense thereto, or to any similar fact evidence to be presented at trial under Section 90.4042 Florida statutes. B. The statement of any person whose name is furnished in compliance with the preceding subdivision. The term statement, as used herein, includes the written statement made by the persons and signed or otherwise adopted or approved by the person, and also includes any statement of any kind or manner made by the person and written or recorded or summarized in any writing or recording. The term statement is specifically intended to include all police and investigative reports of any kind prepared for or in connection with a case, but shall not include the notes from which those reports are compiled. So she's sending all these rules of evidence to the judge like he doesn't know, right? Like he's just, it's his first day in school, and Sarah Boone is there to school the judge, right? Thank you very much, Sarah. I think the judge got it, okay? But she's sending all these rules to the judge to show him, listen, I have the rights of all the discovery. Within 15 days that I send a notice, I have the right. The prosecution has the obligation to produce it. Sure, that is correct. However, what she's complaining about in these letters is that she doesn't have access to all the internet. She doesn't have access to all the lemons, all the shut ins, all the people who are making videos about her. She wants to have the ability to Google herself and see what the world is talking about. So that is not part of the discovery. The discovery is what the prosecution is going to use during the trial to prosecute her. That's what the discovery is not all the internets. Okay. So Sarah, please relax. Okay, so let's see how much more of these rules. Oh my God, she is writing the whole thing, and I don't feel like reading all this. So I think I'm gonna skip when she's just copying, and she's literally just copying the rules of evidence here of what she's entitled to. Um, and then defendant's obligations. So we're gonna skip all the way to page. See, unless that's all she's doing. And then she's doing the American Declaration of Independence, 1776. We hold this truth to be self-evident that all men are created equal, that they are endowed by their creator with certain inalienable rights, that among these are life, liberty, the pursuit of happiness. Sure, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. We the people, this is Florida Constitution of the state of Florida, being grateful to Almighty God for our constitutional liberty in order to secure its benefits, perfect our government, ensure domestic tranquility, maintain public order, guarantee equal civil and political rights to all, to do ordain and establish this constitution. And then here is a another definition, because Sarah has a big dictionary next to her. Clients, attorneys, attorney-client privilege, zealous advocacy, attorney misconduct. She's just giving us all the definitions. Duress, habeas corpus, great wit, what it means. If I think it's just hilarious that she is legal ethics describing to the judge the definitions of all these terms that I'm sure the judge is very aware about, because he had to take the bar and he went to law school and he became a judge after many years of practicing. So I don't know if this is the rest of her letter. Public exploitation, publicity, exploitation, saturation. Okay, so that's what she's talking about, the internet. Let me see if this is her actually talking about her feelings or if it's just more definitions here. What I have received, okay. The number grows daily. Most all letters and messages are available for review and understanding of the impact of my case details being made readily available on the global internet. The global internet. Um, Creating wrongful ignorance. Three things, right? Wrongful ignorance, hate, and massive prejudgment before my trial. I don't think the availability of her case online is creating wrongful ignorance, because we're just watching the actual video. So everybody can make their own minds. Hate. I don't know if people have hates for her. I certainly don't. Massive prejudgment. I agree that there is prejudgment, but I have an open mind. I'm open minded to hear her defense. I, the defendant in my case, have not yet, ongoing 5 years, fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. So, what does she mean by all the case detail? Does she mean like the whole internet and all the searches and all the channels on true crime? She wants to like binge documentaries on herself over the weekend in prison. What does she want? Because the discovery, yes, she has access to the discovery. Now, page 43, the continuation of the obvious exploitation allows the world to keep pressing their, here we go with the multiple words, right? They're incorrect, presumed, unfair theories, ideas, accusations, forcibly insinuating I committed criminal, quotation marks, acts. So, forcibly insinuating, okay? I think the public is able, right, generally speaking, to watch a video of two parties, one in a suitcase, one laughing outside, one saying, I can't breathe, please, babe, I can't breathe. And the other one saying, stupid, F you, stupid. Ha 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 ha. That's what you do when you choke me. I can't breathe, Sarah. I can't breathe. Ha 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 ha. That's what you get. That's my name. Don't wear it out. I think the public is not wrongfully and ignorantly, like you say, Sarah, making any prejudgments, right? I think that we can just watch the video and be like, oh crap, that is a criminal act. Unintentionally or not, like you kept saying, it wasn't intentional, but it's a criminal act to end the life of another human being. My present attorney said it is not necessary to receive a court order. I've been trying to obtain to download my case information to apply from the OCCT tablets. My former attorneys are withholding some of my case contents I have supplied to them and which have been deemed lost in quotation marks, ironically. Many other items have been returned, not to myself, but to the next attorney and which have been unable to be located to date. I am missing innumerable case items which I continuously request to be returned or obtained without success. So here's some more definitions in case you don't have a dictionary rarely available and in case the judge has never been to law school, he's just like in a movie, you know. These are some definitions for the judge: appropriation, intrusion, public disclosure, false light in the public eye, defame, invasion of privacy, false light, publicity, exploitation, and saturation. So let me read this page. It seems very uh, important because it has so many, words that are marked. My personal individual criminal case is being adventurously exploited and abused from all of my significant life savings, suppressible case details, evidence, proof being illegally obtained by coercion, trickery, duress, confusion, and without my permission. That's not true because, number one, detectives are allowed to use trickery. It's allowed by law. They're allowed to lie to the defendant. They're allowed to say, "Listen, we have the evidence. We found your DNA. We have everything against you. So and so already confessed that you did it." They're allowed to lie to you. They're allowed to use trickery. And number two, you did consent because they read your Miranda rights twice and you kept talking, blabbing because you think you're so smart, right? So in okay, without my permission, any form, written or verbal. That's not true because you've signed a consent during the interview to anyone, then broadcasted, distributed, hand delivered to the entire planet. So the entire planet here, just so in case you don't know, it includes states, countries, and continents. That's what the planet means. And Sarah is explaining to us because we're so stupid, right? Containing all of my potential jurors, the planet, causing irreparable, erroneous, falseness, greatly tainting my jury pool altogether by forcibly attributing heavily influenced, incorrect, inappropriate motives. So here, as we can see, she was reading the dictionary under I, and then she was like, okay, influenced, incorrect, inappropriate motives, theories, ideas. So this obvious exploitation and invasion of my privacy. Once you become a criminal, once you kill somebody, once you take another person's life, I don't think you're gonna, and you're in prison, I don't think privacy is something that you get anymore. You know, it's a privilege, it's a right, but you don't have the you're not allowed to take another person's life. That's against the law. So, you know, yeah, you don't have the privacy anymore. Invasion of my privacy is creating unnecessary, so now she's on the U, unnecessary unlawful oppression, depleting all of my entitled opportunities to be given a fair, proper, successful conclusion of my case. Yeah, entitled, you sure are. You definitely are entitled, as misprejudgment has already been made unfairly against me, right? She loves the word unfair, from the undeniable violations of I don't know what that is, my constitutional rights and due process of law, as a result of my entire case and personal life being publicized globally before my rightful trial, which lawfully, ethically, should be without disadvantage and free from any and all partiality, deceitfulness, and dishonesty made from said evident exploitation. So, this is page 46. We're going to stop here today, but we are going to pick up on the next part of this letter. And then we're going to start reading the motions that are more current until we actually start watching the trial. So if you have enjoyed some of Sarah's words here in this letter and you just find it fascinating, the lack of self-awareness, the ability to keep saying that everything is unfair, that the world is misjudging her, that they're erroneously thinking that she committed a crime, quotation marks, please don't forget to like, subscribe, and write your comment on the comment section to let us know what you think about Sarah's mindset. Do you think she still thinks this way today? This is from June 2024. Do you think she still thinks this way today? And if so, who are we dealing with here, guys? So thank you so much for watching, and I'll see you guys next time on the next part of the letter. And part 1 is available on the channel too. So please go check that out. Check out Sarah Boone's playlist for a lot more videos. Have a great day.